If everybody elected to exercise their criminal rights, the system would collapse right upon itself.
The system would collapse, but people would be sitting in jail for 5 years waiting to go to trial.
Welcome to Injustice for All. And today we're going to be very fortunate. We're going to be joined by a longtime friend of mine, over 50 years, one of the most distinguished professors of law in the country, a brilliant guy named Bennett Gershman. He is a professor at Pace Law School. He's written a book, literally, on prosecutorial misconduct. He is a prolific writer. Frankly, most of us who are friends with Ben would wish that his articles had a wider distribution because they're so brilliant and insightful. But we're going to get a chance to talk about not enough topics today with Ben. One of the topics we're going to talk about is prosecutorial misconduct. Another topic I hope to broach is what we call Bello versus New York, which is the obligation of prosecutors to abide by the terms of their plea agreements. And the reason this is relevant today is because of the Ghislaine Maxwell controversy. In part, she is arguing to the Supreme Court that a plea agreement that Jeffrey Epstein entered into with the U.S. Attorney's Office in the Southern District of Florida in 2006 binds the government not to prosecute her. And that's a far-fetched argument because, one, she's not named in that plea agreement, and two, it did not bind any other district other than the Southern District of Florida in executing the plea agreement. So I think she has a very hard road to convince the Supreme Court to take her case, but in today's world, we've been surprised by the Supreme Court many times. So without further ado, let me introduce you to my good friend, Bennett Gershman, and we'll talk about all these topics.
Okay,
Good morning,
thanks,
Ben.
Bob. Morning, Bob. Thank you.
How long have you been a professor?
I hate to say it, but next year is going to be 50 years. And the law school, as a matter of coincidence, opened 50 years ago in August of 1976. And it had 5 professors, a dean, and a librarian. I was one of the 5 professors. And I guess 50 years is a milestone. Some people
That's for
say.
sure. So you've written a number of books, at least 4 that I'm aware of.
Yep.
And as well as authored 75 or 100 articles on topics in the criminal justice field. One of your books, the treatise on prosecutorial misconduct, is used everywhere. Lawyers, scholars, law students. In today's world, what do you tell your students about the criminal justice system? Is it working? Is it failing? What do you tell them?
I tell them that it's an exciting opportunity to be a lawyer. I tell them that if you're a prosecutor, you're going to win almost all the time. If you're a defense attorney, you're going to lose almost all the time. I tell them that it's an opportunity to serve the public if you're a prosecutor, and it's an opportunity to learn the skills of criminal defense. In litigation is litigation, but it's the criminal law field is a really exciting place, and I tell them that they have to be careful because the rules are such that unless you are totally committed, totally aware, totally conscious of what you're doing, you can get into trouble. I tell them that being a prosecutor was probably the best professional time of my life. I mean, I love teaching, but I don't consider that, lawyering in practice. I told him that as a prosecutor, I love to come to court every day. I love to deal with my colleagues. We felt we were uh, kind of on a mission to serve the public, to vindicate the rule of law. And it was an exciting time. But look, as a prosecutor, I learned that not all prosecutors felt the way I did. Um, when I say felt the way I did, I mean that you've got to understand that you, that cases are not easy. No matter who the defendant is that you're prosecuting, you really don't know everything. And I all I really require of prosecutors, of lawyers in general, is that you really struggle with a case. You, I mean, really, you take a kind of a skeptical view of the case until you really are convinced, personally, confident that you have got the right person. And I think you should feel that you have to feel beyond a reasonable doubt, almost morally certain that this is a correct case, that it's a safe case to prosecute, and then you can go ahead with the prosecution. But, I think there are too many prosecutors out there, maybe too many lawyers, I don't know, who don't struggle, who are pretty complacent with the evidence, with the facts. They maybe take a tunnel vision of the case, and that's dangerous. So really what I'm saying is being a lawyer in general and being a prosecutor requires it's to me it's the biggest challenge of all to be a prosecutor. Let me tell you why. Because there's a line that you want to reach, a line of ethical conduct. You want to get as close to that line as you can in prosecuting your case because you want to do the best you can as in terms of prosecuting and convicting a guilty person. But you can't cross that line. And so where is that line? Well, that's a big challenge to begin with. Where is that line? And secondly, getting close to the line, but not crossing it, to me is probably the biggest challenge for any lawyer, I believe, because it does force you to be so aware, so concentrating on what you're doing, every second, every moment, and you live with the case, you live with the you know the witnesses. You think all the time about convincing the jury. Uh, I mean, I love the work. I tell my students that it's a terrific opportunity to serve the public, to learn the law, to um, feel that you're doing something really uh, hot, professional and positive. But it's very difficult. People burn out, and people get in. I don't know. That was a long-winded way of thinking about my work, and I've written about it because I think it's so important for people to know about this area. When I wrote my book, there was nothing out there like that. There were a lot of cases, but it seemed that the area was chaotic. Nobody had really organized it in any way. Nobody had put the cases together in any pattern or in terms of topics and issues and things like that. So I saw that as an opportunity to try to do it, and I did it as best I could, and apparently it was relatively successful. And I keep updating the treatise every year because every year it seems new things happen, new cases are decided that raise new issues. I mean, that from just following the courts and the Supreme Court that there are just new issues and sometimes just repeating the areas where prosecutors fall down. I'm thinking about disclosure of evidence. I'm thinking about the prosecutor's inflammatory arguments in court. I'm thinking about prosecutors who don't take a close look at the case. And I'm thinking about so many individuals who have suffered miscarriages of justice, innocent people, exonerations. I mean, the number of exonerations in this country since records were kept in the 1980s, but there were loads of it before that. But the number of exonerations, you're talking about thousands and thousands and thousands of individuals who were convicted, spent years, decades, their life in jail for a crime they didn't commit. When you think about that, you really have to feel concerned and I mean, more than worried. I mean, this is a tragedy for these individuals, for their family. And I lay a lot of the blame to prosecutors. If there's a defendant who is found to have not committed the crime, he's been exonerated. I mean, I really look at the prosecutor first because it was the prosecutor who prosecuted that person. Now, in some cases, I'll accept that the prosecutor has evidence. The prosecutor scrutinizes the proof. The prosecutor has an eyewitness, and the prosecutor trusts the eyewitness. But now that we have DNA evidence, we know how many eyewitnesses are wrong in their identification. And I just have to say that it's the prosecutor to begin with who makes the decisions. No other country in the world gives its prosecutors so much power and discretion as America does to its prosecutors. And I also have to say that there's very, very little accountability. The courts don't exercise much accountability. The disciplinary bodies, I think, are almost totally asleep when it comes to prosecutors. So it really does depend ultimately on the integrity of the individual prosecutor to do the right thing. And I have to feel that most prosecutors, I believe, are people of integrity and professionalism and believe that they know their power and they know that they have to exercise their power properly and cautiously and responsibly and all that. But there are too many prosecutors, just like there are too many police, who cross the line. And some of them even know they're crossing the line, but they don't care. And that's bad.
So the book you're referring to that you put together is the Professional Misconduct book, yes?
The book is called Prosecutorial Misconduct.
Right.
Prosecutors don't like the title because they think prosecutors don't even like to use the word misconduct. To a prosecutor, get rid of the word misconduct and put in the word error. Error is okay. We made a mistake, inadvertent. They like to think of it as a mistake. But the fact of the matter is, most prosecutors know what they're doing. It's not a mistake. It's either it certainly is bad judgment, bad, terrible judgment, and maybe deliberately violating the law to win the case.
Well, you were a prosecutor in the Manhattan District Attorney's Office under the legendary leadership of Frank Hogan.
Right.
And then in the Special Prosecutor's Office in New York State under the leadership of Maurice Najari.
Right.
Two very well-respected offices. What led you, after that experience, to write a book about prosecutorial era misconduct?
I knew about it. I mean, I was a prosecutor for over 10 years. I knew prosecutors. I tried loads of cases. I did a lot of investigations. And I guess I just felt something happened where I realized that this was a big area of the law that nobody had ever dissected and analyzed and organized in a systematic way. I wanted to make it systematic. What are we talking about when we talk about the conduct of prosecutors? And when you talk about the conduct of prosecutors, you're talking about the criminal justice system from A to Z, because the prosecutor is involved in every single step along the way. And so and I was, very skilled in criminal law. I began teaching here at Pace, criminal law. And so I felt that I had knowledge, I had the experience. And now I began to devote myself to lots of hours of research and thinking about how to put it together in a systematic way. So the book really has, what is it, 14 chapters. Each chapter is a particular segment of that long story of the prosecutor's role in the criminal justice system from beginning to end. And so I guess I systematized it, I organized it, I talked about it, I talked about where the prosecutors go wrong. In other words, I talked about what the rules are, what the ethical rules are, what the legal rules are, what has the Supreme Court said about this area, because the Supreme Court talked about prosecutorial misconduct way back in the 1930s. This isn't something new. And there was a famous essay by a former judge way back in the early 20th century where he was talking about inflammatory misconduct by prosecutors in their summations to the jury. So there was a lot there, but nothing was put together in any, reason, way that people could see it in this in an organized, systematic fashion. So that's what I did. I mean, it was an idea I had, and I did it. And I guess, looking back, it worked.
So there are rules for prosecutors. We're supposed to, as a prosecutor, turn over discovery, that meaning documentation and other evidence that has been developed by the police or federal agents. We're supposed to turn over anything that is exculpatory, that may help a defendant. Whether we think it helps them or not is not our decision to make, but is for the defense to make that decision. And every time I've heard over the course of 50 years, a defense attorney say to a judge, hey, we think there's Brady out there, the judges will turn to the prosecutors and say, well, they know their obligation. I'm not going to force them to do more than understand there's a penalty if they don't live up to that obligation. But they don't, because if there's any particular violation that seems to upset appellate courts, it's the Brady violation. So can you tell us what that means?
The name of the case is Brady v. Maryland. It was decided by the Supreme Court in 1963. The Supreme Court said, in essence, the Constitution, due process clause, commands prosecutors, when they know of favorable evidence favorable to the defense, they're obligated to disclose that evidence to the defense. It's a simple rule. And now, the prosecutor will collect most of the evidence in the case because it's the police are going out there, the police are doing the investigation, the police are talking to witnesses, the police are doing forensic evidence, stuff like that. So virtually all of the evidence will ultimately go to the prosecutor, who will then look through and decide whether or not to accuse the defendant, and then the evidence goes to will go into trial to the jury. But in that huge mass of evidence, there might be evidence that shows that an eyewitness said the defendant didn't do it, or there's forensic evidence that exonerates the defendant. And the prosecutor knows about that. And the case is about to go to trial. Now, let me just throw out this hypo for people to think about. I mean, let's assume that, you're a football team, and you're playing this big game. And the rules require you to give to the other team all of your plays and your secret, how you're going to make your moves to win the game. You have to give your plays to the other side. I mean, that sounds crazy, doesn't it? Because if you give your plays to the other side, they're going to take advantage of it. They're going to use it against you, and you're going to lose. Now, if some prosecutors think like that, I want to win the case. If I have to give evidence to the other side that might help the other side win the case, oh, what prosecutor would do that? It sounds so counterintuitive. It sounds crazy that I'm going to give them evidence that they're going to use against me. It's like I'm tying one hand behind my back. Uh, and that's the psychology that a lot of prosecutors think about. And so, some prosecutors realize, look, that's the rule. It's a legal rule. It's a constitutional rule. It's the ethical rule. I got to do it. But a lot of prosecutors aren't going to do it a lot. I mean, they may give a little bit here and there, and they're following their obligation. But I'll make you a bet that there's this important evidence that many prosecutors see that if they give to the other side, they're going to lose the case, or they're going to make their chances of winning much weaker. And so they'll bury it, knowing that if they bury it, put it in a drawer in their office, or nobody's ever going to know about it. They're not going to know about something that doesn't exist. They're not going to know about it. How will they know about it if the prosecutor hides it? I mean, that's kind of like the catch-22, that the prosecutor knows if he gives it to the other side, it's going to give them more ammunition to win the case. And so, a prosecutor that wants so desperately, fiercely to win the case, and many prosecutors have that conviction mentality, why would they rationally give that evidence to the other side? Now, if that's your constitutional obligation, because the ethical rule for prosecutors is something like this. The prosecutor is more like a judge than like a defense attorney. The defense attorney has one allegiance to his client. The prosecutor has an allegiance not to any particular person. The prosecutor has an allegiance to the cause of justice. We're talking about justice in a big way. And justice means you do the right thing, you don't cheat, you don't take advantage of the other side, you don't cut corners. Justice means that you're following proper, ethical, impartial ways to do your work. Because the prosecutor is like a quasi-judge. And the prosecutor does have to strive to do justice. Yes, the prosecutor wants to win the case, of course. The prosecutor wants to convict bad people. Sure. And you want to use all the weapons that you have in a proper way to convict people who have violated society's rules. Sure. But you're really wearing two hats. You want to convict bad people, but you also want to make sure that you do it in the right way. You do it according to the rules, the constitutional rules, the legal rules, and the ethical rules.
The Supreme Court has spoken of this many times over the course of almost 100 years now, and yet it falls on deaf ears often. Not every prosecutor does this, but many do. Their interest in winning supersedes, as you're pointing out, any obligation that they have to turn things over. And the obligation of Brady is not to turn it over when you're getting close to trial or at trial, but to turn it over when you see it and find out about it. But rarely does that happen. And most defense lawyers continue to say to judges, I don't think I've gotten all my discovery. I don't think I've gotten all of the Brady material that exists. And the judges, as I say, essentially just say, well, that's on them. If they don't produce it, then you find out about it, you'll get a victory on appeal.
And the problems you hear about are that on appeal, there are rules that are going to keep the conviction intact, even though the prosecutor cheated. I mean, one big rule we know about is called the harmless error rule. The appellate court is going to look at the evidence, and if the evidence looks pretty strong that the defendant might have been convicted anyway, they're going to ignore the fact that the prosecutor hid important evidence. Maybe evidence that wouldn't have decisively tilted the scale, but evidence in the defendant's hands where they could have used it responsibly maybe to show that the prosecution's case was weak. But the prosecutor hides the evidence thinking, I'm going to get a conviction, and the appellate court is going to affirm that conviction, finding that what I did may have been an error, but it wasn't such a big deal. So the harmless error rule stands in the way of prosecutors doing the right thing, prosecutors believing that they can cheat and get away with it. And, beyond the appeal, there really is virtually no ethical oversight here. Because if you look at the numbers of times that disciplinary bodies throughout the country, federal, state, have disciplined prosecutors for violating the rules, really, it hardly ever happens. It's pretty sad when you look at it. I mean, the disciplinary bodies, to me anyway, are like paper tigers. They can talk big, but they never really tackle prosecutors. Why? Well, prosecutors are powerful. Prosecutors are political. It takes a lot of resources to go after a prosecutor. It happens sometimes, very, very rarely. So to me, the absence of discipline, to me, the absence of any real accountability by the judiciary, to me, the prosecutors in this country enjoy almost total immunity. I mean, they do have absolute immunity from civil liability. We know that. That's pretty clear. Prosecutors hardly ever might be charged with criminal conduct. And there are crimes that prosecutors commit, soliciting false testimony from a witness. That happens, I would say, too often. Hiding or destroying evidence, that's a crime in most jurisdictions. So prosecutors commit criminal offenses from time to time, clearly so and clearly provable, but they're never prosecuted. They're too powerful. They're too important. That our system just doesn't work that way. And prosecutors know that. They know what their power is. I mean, I'll tell you, Bob, but last year we had about 10 or 12 of my graduates from my law school come back who became prosecutors. And we had like a panel discussion. And the one thing they all said was, I never realized how powerful I was until I came into the DA's office. I mean, it was a startling shock to a lot of them how powerful they were, how much they could control the system and the police and witnesses. It's interesting.
Well, we reference Brady violations, and we talked a little bit about the harmless error rule that you just mentioned. But it's not simply limited to Brady violations. Essentially, any prosecutorial misconduct may not be the subject of a reversal of a conviction based on the harmless error rule. That's fair to say, right?
Mm-hmm. Yeah.
I mean, prosecutors will say things in summations that are clearly improper, are intended to prejudice the defendant, are inflammatory about things that should not be said, talk about things that are not part of the evidence, and yet the number of cases reversed on that basis are almost non-existent.
Again, think of the psychology of the jury. Prosecutors know that they have a huge advantage in the courtroom with a jury. Who's the jury going to believe, the prosecutor or the defense lawyer? Prosecutors know that they're seen by the jury as riding on a white horse and the champions of justice. And I think there are loads of social science data with mock juries to prove that almost conclusively. So prosecutors know that the juries like them, listen to them. And so prosecutors can inflame a jury, can talk about maybe evidence that really wasn't admitted, can talk about unused evidence that they have, can vouch for, I know the defendant is guilty, their witnesses are lying. I mean, prosecutors can say things and the juries will eat it up. And when it gets to the appellate court, the appellate court will say, well, the prosecutor went too far, shouldn't have done that. But it really didn't matter that much. All lawyers go out, exaggerate and cross the line from time to time. A trial is a very aggressive contest, and lawyers are going to say things sometimes that maybe they shouldn't say, but that's just the way it is. So the vast majority of the appellate courts, uh, they may not condone, but they tolerate, the excesses.
And that's more true on the federal level than state level, in my experience.
Probably, probably. I mean, the federal courts, they think that the system is much more refined and elegant and protective, and so they give a lot more toleration to their the federal U.S. attorney, the citadel of justice, and all that stuff. Although you look at the attorney general's office today and the justice departments around the country, they're stooges for Donald Trump. It seems to me they're doing whatever Donald Trump wants them to do. And prosecution to me today, at least at the federal level, is very, very dangerous, uh, worrisome, very worrisome, in terms of whether they're doing the right thing or whether they're getting rid of cases for political cronies. They're going after the enemies of Trump and stuff like that. That's happening today in a way that makes us all uh, very, very concerned about where our country is going in terms of criminal justice anyway. But the states are still there. And we know that, by the way, a number of prosecutors' offices have created what we call conviction integrity units, which review cases that maybe were questionable. New York has just created a prosecutor conduct commission to look at prosecutors, although that commission doesn't really have a lot of power. It's still in the hands of the disciplinary body, but there's a little bit of concern today, and I think that as I see judges around the country, maybe they're more aware that of the power of prosecutors and the ability of prosecutors to tilt the scales against the defendant in favor of conviction, and that prosecutors cheat. And I think that maybe more judges are aware of that anyway. But the problem is, a lot of those judges were prosecutors, and that's how they got to be judges. And so I wonder how close they're going to hold the prosecutors to toe the line of ethics and legality and things like that.
So many of them become the extra prosecutor in the courtroom.
That's true.
That that even when the prosecutors who are at the prosecution table fail to undermine a witness, a defense witness, or fail to highlight something that could help the prosecution, oftentimes those judges will make the points for them, and or will restrict the defense lawyers in ways they should not. And yet they rarely get reversed because of that.
You see that a lot. Exactly right. And the appellate courts are reviewing the conduct of a judge in the trial. You know that they're going to give a little bit of latitude and indulgence to that judge. They're not going to be too harsh on that judge because they're part of the same club. So, and judges, some judges, the judges perhaps who were prosecutors, or the judges who just feel so involved in the case, they want to talk, they want to ask questions, and they want to make comments. They rarely do it against the prosecutor. They almost always do it to kind of control and put down the defense attorney. And if the prosecutor makes a mistake, they correct it. The relationship between prosecutors and police and the relationship between prosecutors and judges is something that's the reality. And I don't think there's any other country in the world where that type of setting and those relationships are as extreme, as they are in the United States. I mean, again, our criminal justice system. I mean, I wrote a piece 30 years ago where I talked about the new prosecutors and the increasing power that prosecutors had in terms of new crimes, in terms of less accountability, in terms of no discipline, stuff like that. And the journal asked me to do an update. They thought it was a really good article. They got a lot of attention. They wanted me to do an update. So right now I'm trying to update that article. And you know what? Way back then, when the system was so imbalanced in favor of the prosecutor, so skewed for the, and I look at it today, it's far more imbalanced in favor of the prosecutor. If you look at everything that's going on in terms of new crimes, in terms of resources, in terms of police, in terms of technology, today, it seems to me it's if a defendant doesn't plead guilty, like 99% of the defendants are going to plead. If they don't plead guilty, they're facing such a harsh punishment. So that's why prosecutors now lord over a system where 98, 99 out of 100 defendants plead guilty and go to jail for less time. And that's not a great system. We never, to me, because a lot of them are pleading guilty, not because they're guilty, but because they know what will happen if they go to trial. And they don't want to risk it.
They believe and have found out that the penalty for exercising your constitutional right to go to trial can cost you additional time in prison.
Many additional years in prison, yes. And it's a calculation that many defendants make. Sad, tragic, yes. But they realize the reality, and your lawyer probably tells them very clearly, this is the reality today. The jury's going to convict you even though you're innocent, or even though you didn't do what the prosecutor says you did to that extent. You can reduce your sentence by a third, by a half more. And that's where we are today in terms of criminal justice. It's not a great system, but it is the way it's always been, only it's far more skewed in favor of prosecution and conviction.
And if everybody elected to exercise their criminal rights, that is, to go to trial, the system would collapse right upon itself, would it not?
The system would collapse, but people would be sitting in jail for 5 years waiting to go to trial. The system would collapse, and prosecutors know. Everybody in the system knows that, so they're working out a way of streamlining it so that the system can move ahead efficiently. And yes, that's one of the reasons why plea bargains happen. We know that it's a necessary evil, I've always felt, but today it's really gotten much well beyond what it used to be. I mean, we used to think maybe 9 out of 10 defendants plead guilty. I mean, the same number of people in civil litigation settle cases the same kind of way, but now it's even more than that. And that's because of the increased punishments, mandatory minimums, things like that are almost, these laws are coercive in terms of making defendants plead guilty rather than going to trial.
And the federal sentencing guidelines codify that you get additional points off of your potential score and exposure if you accept responsibility. Right.
So as you're saying, how does somebody who's not guilty accept responsibility? So, when you're if you're an innocent person, you're convicted, you're in the prison, and you go before the prison, parole people, and they want you to say I'm guilty before they give you parole. But if you didn't do it, how can you say? How can you show remorse? How can you show, that you feel bad about what you did? It's a bind for too many people in the system. And then, you want to spend a few minutes talking about the state of our prisons. That's not a very good topic to talk about either, because people don't want to talk about what happens in prisons. It's sort of an abstraction that people kind of put out of their minds. People don't want to talk about the place where these immigrants are being held today in different parts of the country. The conditions oftentimes are horrendous, and we sort of we don't want to think about stuff like that, but that's a big part of the criminal justice system. The cages where people are being incarcerated. and the conditions there, and on and on and on, on and on and on. It's a long, it's a story that keeps going on and on, getting worse and worse and worse. It seems to me, anyway.
Well, it extends even well beyond the cages that are being built, the Everglades prison and the like. Even in the Bureau of Prisons, the Federal Bureau of Prisons, the prior director said she needed $5 billion just to try to patch the problems with the foundation, that is, the physical structures where
Yeah.
people are housed. And having been there, I can tell you it's awful. But who cares? Listen,
Exactly.
all these people who are in prison, they deserved it. That's a general attitude a lot of people have. Not so. As you pointed out, there are many exonerations. In the recent book written by Jim Grisham and Jim McCluskey, Framed, I think is the name of it, they talk about cases. I read it. I couldn't even believe it myself. It was so horrific.
You start talking about these anecdotes. Um, the one thing we don't do, which maybe we can't do because of the volume of cases, there are other countries where if there was a wrongful conviction, an innocent person got convicted. In many countries around the world, that is a big deal. And you know what they do? They hold a post-mortem. They have a commission, and this commission is now mandated to examine closely why did that happen. So like a plane crash, to try to understand what went wrong. You know, thousands and thousands and thousands of cases went wrong. Thousands and thousands of defendants were innocent. But you tell me one time where there's been a commission to examine, analyze, call witnesses. Why did this happen? How did this innocent person get to be convicted? I know one case where it happened. It happened to be a student of mine, actually, was when he was a high school student up here in Westchester County in Peekskill. He was charged with murdering a classmate. He was, I think, 16 years old. She was 15. The police interrogated him, and this young man was not a brilliant person. He had limited mental ability. He was emotionally, just problems. And the police questioned him for a whole day into the night, I think 10, 12, and finally, lying on the floor in a fetal position, he said, okay, I did it. Now, maybe not enough people out there know that there are many, many times innocent people confess. We know the Central Park jogger case. The 5 young African-American teenagers confessed and they were all innocent. So innocent people confess. Anyway, he was sentenced to life imprisonment. The judge wasn't sure he did it, but he sentenced him anyway. And this young 16-year-old spends another half his life in prison before they did DNA testing, and they concluded that he didn't do it. He wanted to go to law school. I got him into my law school. His name is Jeffrey Deskovic. He's now running a foundation. He got a huge, compensation for what happened to him, and he used it to create a foundation for people who are wrongfully convicted to get exonerated. He's hired lawyers. He's hired investigators. It's an incredible story. But what we're saying though is in that case, I got to give credit to the district attorney. The district attorney investigated how he got to be convicted. She got a panel of 3 experienced prosecutors who were prosecutors together to call witnesses to find out why the system broke down like that so that this young man was convicted. He had a horrible lawyer who was drunk some of the time. The judge was not that effective, and the prosecutors cheated. The prosecutors hid DNA evidence. And by the way, while he was in jail, and people were, an innocent person is in jail. The real killer is out there. The real killer killed again while he was in jail, believe it or not. So But what I'm pointing out is that's one place where there was this investigating body looking into that case, but it never really happens. You never look back. You never try to figure out why was this innocent person convicted? What happened? Was it the police? Was it the prosecutor? Was it the judge? Was it a lousy defense lawyer? But we don't do that anymore because maybe it's just too much time, too much effort, too much resources. We got so much to deal with in terms of present crime. Why talk about past crimes and innocent people and stuff like that?
Well, even I know we all have heard about DNA testing and how so many people have been exonerated with DNA testing. But in most states and in the federal system, it's not so easy to get the government to agree to DNA testing.
That's a great point, Bob.
Right. So you may think, oh, everybody in prison is going to get that and they'll be able to prove they're innocent, but they're not.
It's a great
The
point.
state opposes it. The federal
And the
people
Supreme
oppose it.
Court and the Supreme Court endorsed that practice of you don't have to do the testing if you don't want to.
Right. So it's you may read about stories that of people being exonerated after 20, 25, 30 years. They're the rarity. There are many more there who would have been. And we thank God that there is such a thing as DNA testing for those. But I keep coming back in my mind to the Brooklyn District Attorney's Office. There was a detective there who used the same informant in multiple homicides. He was the eyewitness in multiple homicides. That what's disturbing is not one judge, not one prosecutor said to themselves, how did the same informant see every one of the homicides that this detective investigated? Years later, the new district attorney, Gonzalez, put together a review group, and they found out that every one of these cases had to be overturned, that the informant was lying and the detective knew it. But there were no consequences to the detective. And we ultimately paid these people for the years that they lost. How do you compensate somebody for being in prison for a year or two? What has that done to him or her? What has it done to their families? There's no way to compensate them.
You know, that's a great question to people. Do you want to be a whistleblower? Do you want to blow the whistle on colleagues in your DA's office or in the police department? You know that if you do, it's unclear what the consequences are going to be. You could be thrown out of your job. You could be in trouble yourself for blowing the whistle. There are reasons why you might want to do it. Just a matter of integrity, courage, maybe even reward. I don't know, but people are ostriches a lot of the time. They bury their heads in the sand, and they don't want. I see no evil, hear no evil. Just leave me alone. I'll do my job, and I don't care what you're doing. I don't care what. We'll just go on with our work, and if we know something is wrong, we'll just sort of deny it or put it out of our consciousness and just move ahead. Indifferent, complacent, concerned that we'll be getting in trouble. So today, my opinion in terms of lawyers, in terms of I don't know, there seems to be a lot more people crossing the line between honesty and dishonesty. I just fear that today because I think they take their cue from the president of the United States. If he can get away with it, I can get away with it, something like that. And I think the consequences of a culture where it's okay to cheat or I'll get away with it. Certainly for lawyers, most lawyers know that they're probably not going to get caught if they cheat, if they cross the line. And I worry about that because I teach future lawyers and I am part of the legal system. And I believe that there's more crossing that line, dishonest conduct, malpractice today than ever before. That's my opinion. And it's going to be very hard. But we know how many lawyers were involved with Trump that have been disciplined, charged with crime, convicted. You know, I mean, I think it's getting close to 50. You didn't have that with Watergate. You didn't have that with the lawyers surrounding Richard Nixon. But you have it today. And that's something that I think we all should be worried about because, the legal profession is the body of people that protect the rule of law. And if the rule of law is not protected by good people, then we don't have law anymore.
Well, maybe that dovetails in the two recent articles you wrote. One, the Spineless Supreme Court, and the other one was written this week about the number of lawsuits that the president has filed. It can
Against the media,
explain that.
against the media, against the media. Yeah, the
Yes.
president. I mean, we have something I called it the SLAPP suit, strategic litigation against public policy. It's bringing lawsuits by powerful people like businesses, corporations. They bring lawsuits against somebody for criticizing them, and they know they have the power to overwhelm that person in a lawsuit, make motions and resources that they have to expend. It really puts a vulnerable party in a very bad thicket because they really can't. They don't have the resources. They don't have to respond to the big, powerful lawsuit. And Trump knows that. I mean, he's dozens and dozens and dozens. He's sued, I think, more than anybody in the history of America. I mean, he's over 4,000 times he's brought lawsuits, but now he's suing New York Times, the Washington Post, and the Wall Street Journal just recently about the Epstein case. And he knows they're going to lose. He's going to lose, but he's making everybody worried that they have to now defend. They have to expend resources. They have to and so a lot of people are going to say, well, maybe I shouldn't be so critical because if I'm critical, I might get hit with a lawsuit by this guy. And I don't want to have to get into that situation where I've got to waste time and money and all that stuff. So that's a kind of strategic litigation. That is something that if people don't want to criticize anymore because they're worried they're going to get sued, what happens to free speech? What happens to the First Amendment? Do we have a First Amendment anymore? Are people so worried about speaking out that they remain silent? So this is a silent population. Democracy can't work like that if everybody's silent. For democracy to work, people have to exercise their First Amendment right to speak and freedom of the press and all that stuff. Now, a lot of people are doing that, but I'll bet you a lot of people are worried. A lot of people are deciding it's better to be silent than to criticize.
We have law firms that have done that.
Right.
They just don't want to lose money that they may earn from government contracts or representing clients who have those. And they'd rather agree to an extortive move to say, I'll pledge $100 million worth of pro bono free services rather than defend our position.
And look what he's doing to the universities. I mean, he's destroying these citadels of knowledge and learning, basically saying to them, unless you follow my rules, you're not going to get any more funding, and your reputation is going to be hurt, and people are going to come to your school. And so, how many universities are now, deciding to be quiet, not to rock the boat, follow the rules in terms of diversity and equity? I mean, look what's happening in terms of our scientific research. I mean, they're losing some of the best people who would be able to, the research that is now being halted or diminished. Research into cancer, research into Alzheimer's. I mean, people are saying that the funds for that research are now being diminished so greatly that we're not going to have the same ability to deal with people who are ill, people who need help. The Department of Health and vaccines. Maybe a time where you're not going to be able to get a vaccine anymore. I mean, I mean, what's happening? What's happening to this country? I mean, this great country is destroying itself right now, and I don't know that people see that. they may see it as the economy starts to tank. They are seeing it in terms of what's happening to migrants who have committed no crime and they're incarcerated in these hellholes around the country. Um, I mean, they're seeing it in the new Gestapo, the ICE people who are just rounding up people. I mean, what you're seeing is something that is not what America is or was to most people. They see a horrible time here that and they don't know whether it's going to end. They don't know whether it's going to get the hole is going to get deeper and deeper and deeper. Have we hit the bottom? No, we haven't hit the bottom, folks. The bottom is far from being hit, and so are you worried? Yeah, you should worry.
How much of this do you blame on what you called in your article the spineless Supreme Court?
Well, of course, it's a sad day when you see a court that you once revered, the majesty, the great Olympian, court. You see the court just so hyper partisan. So many of them have committed so many blatant ethical violations, and they're just caving into this president. They gave him absolute immunity last year. This year, they're just oftentimes giving him everything he wants and more in terms of his ability to override Congress, and the Constitution gives Congress primacy in terms of funding and allocating funds. Trump is doing all of that, and the Congress is just remaining silent, and the Supreme Court doesn't care. And so case after case, the court is giving Trump a green light, a license. Do whatever you want. We're not going to stop you. We believe that a president is the president, and the president should wield the power. But how much power does the president have? I guess the Supreme Court says as much power as you want. And we're not going to stop you. I mean, that's maybe a little bit beyond, but I can't say that this court is going to do anything to rein in the president in any significant way.
I mentioned to you yesterday, I sent you an email, you and some others I know, about how the online place you can go to listen to an oral rendition of the Constitution of the United States had now eliminated from there several parts that talked about the power of the Congress, including the right to habeas corpus. Now, I don't know whether they'll correct it now that the media has caught on to this, but can you imagine just it's no longer part of the Constitution?
Well, yeah, that was just an almost incredible story. But Bob, let me just say this as we're going to have to end, I suppose. Voting, democracy works by people voting. And right now, what we're seeing is the Republicans doing everything they can to rig the vote. They're doing it in Texas by gerrymandering. They're going to be doing it in other states where they hope they can do gerrymandering to get more representatives in Congress. They're going to try to disenfranchise as many people as they can. And they know that if it was a fair vote, they'd lose. But if they can rig the vote in different ways, they can keep power. And by keeping power, by rigging the vote, do we have a democracy anymore? So that's probably for a lot of people today something that is, more worrisome to me than taking habeas corpus out of the Constitution, although that's never going to happen. But I worry about the way our right to vote today is being infringed, usurped by all of these games, all of these tactics, these gambits that they're doing. That to me is one of the most scary things because if you can't win on the merits, cheat and you can win, and that's what's happening today to me. And I don't know where that's going to go, how far that's going to go. I guess there has to be some pushback. The Democrats and independents strong enough to push back on what we're seeing in terms of the diminishing, in terms of the cheating that we're seeing going on.
Let me take you back to prosecutorial misconduct for a minute. I mentioned at the outset Ghislaine Maxwell's case that's pending before the Supreme Court, and I mentioned that she was relying upon what is a precedent from the Supreme Court called Bello versus New York. Can you explain how prosecutorial
Yeah,
plays into that
I got,
and
I
what
got,
she's arguing?
I got to tell you, Bob, because you and I, there may be some telepathic transmissions here. Because just the other day, I reread Santabello without, and just the other day, I went back over the Florida plea bargain, that the sweetheart deal that Epstein got. Um, Santabello basically says to, if you make it's like contract law. If you make you got an agreement, you got to stick to your agreement. You can't cheat. You can't breach your agreement. That's to me the essence of Santabello. If one prosecutor makes a deal with a defendant, and now that prosecutor, let's say, is out of the office, and a new prosecutor comes in, you can't unmake that deal. A deal is a deal. A bargain is a bargain. I mean, you don't even need criminal law here. You've got contract law, and a breach of the bargain, you pay a big penalty. You can't breach a bargain. Um, and so you know, I think, what was the bargain that was made with Epstein in Florida? I'm not so sure, Bob, that she's not doesn't have a good argument. It seems to me that this non-prosecution agreement, NPA, whatever, basically said that Epstein could not be prosecuted by a federal authority, and I'm not so sure it was just Florida. I understood that the feds wouldn't prosecute him anymore. I understood that the feds wouldn't prosecute any of his co-conspirators. And by the way, the deal was so stupid, but the prosecutor didn't even know who the co-conspirators were. Maxwell, she wasn't even mentioned. I don't think they knew about her. But they basically, any co-conspirator can't be prosecuted either. So it was probably, I was going to write an article in the Law Journal. Maybe I will, maybe I won't. I thought that Florida deal with Epstein maybe was the worst plea bargain in American history. I mean, because they gave him, I think it was like a misdemeanor. He did a little bit of jail. He could stay in his office. It was virtually they didn't notify any of the victims. And this was one of the most horrific crimes, sexual crimes that one could imagine. And he got away with everything, virtually. And this guy Alex Acosta, who was a U.S. Trump later on made him Secretary of Labor. Of course, maybe that was a payoff. I don't know. But it was a terrible, terrible bargain. And Maxwell is, they're doing the same thing today. They wanted to try to talk to her about releasing grand jury testimony or whatever it was. They didn't even bring the victims into the situation. And victims have rights. They basically just no, the victims were ignored back in the plea, and the victims were ignored again today when they're talking to Maxwell. So history repeats itself, and at least the situation is getting exposed. The dirty, ugly situation involving Epstein and arguably Donald Trump and others, at least is getting exposure, which is a good thing, I think.
So you mentioned that victims have rights and that Acosta ignored those. Well, what are you specifically referring to so that people will understand the concept?
Well, victims should have at least be heard by the prosecutor if they're going to take action against a defendant. What did the defendant do? How injurious was it? So to understand that, you want to talk to the people who were injured. You want to talk to the young women who were pulled into Epstein's orbit and forced, trafficked into sex. I mean, a prosecutor must do that before deciding to make a deal with the defendant. You want to be able to hear what happened and show a certain amount of sensitivity, show a certain amount of concern about the individuals who were so injured, damaged, suffered by this defendant's crimes. Acosta didn't do that, and they're not doing it today. And victims have rights. There's a federal statute. Every state has a statute that says the rights of victims. Now, the victims can't control the prosecution, okay, but at least they have to have a say. They have to be, shown some sensitivity, some concern by the person who's prosecuting the case. They didn't do it back then. They're not doing it now, and that to me is another mark of opprobrium against those prosecutors who ignore the victims. To me,
well, what happened with her as well? I mean, she was interviewed for 2 days by the Deputy Attorney General, almost an unheard of scenario. I mean, usually you send the agents who investigated the crime or the prosecutors who prosecuted the crime. In this case, the number 2 person in justice went there.
Who is Trump's lawyer?
Yes, that's true too. And then, in the way the Bureau of Prisons works, if you're going to be transferred, you're only allowed to be transferred to certain places based upon the internal regulations. They ignored that and granted her an exception. And beyond that, even if the exception were to be granted, you get on a bus with other inmates and you travel to a hub. And then you're in that prison, that hub prison, for a couple of days. And then you get on another bus or a plane and go where you're going. She was transported overnight by herself in a plane from Florida to Texas. It's just unheard of preferential treatment.
Wow, preferential treatment under the Trump administration with all of these Trump lackeys following Trump's orders and doing the things they want to do. Preferential treatment. Oh my gosh, Bob, can we imagine the horror of people getting preferential treatment, people violating the rules, people. Come on, we're in a different time today. This is
no doubt. But anyway, Ben, I know you've taken invaluable time to be with us today, and I really appreciate it. I definitely want to have you back in the future. We'll talk about other things because there's so much to talk about. Sure. And we've witnessed it, lived it together.
Right.
And it continues. So the topic never gets old.
Bob, I enjoyed being with you. I'm looking forward to doing it again. Thank you.
All right, Ben. Bye.
Take care. Bye-bye.
Well, Ben Gershman was terrific today, and we're only touching the tip of the iceberg of what constitutes prosecutorial misconduct. I mean, he's written a book that's hundreds and hundreds of pages with thousands upon thousands of examples of this. The more we know, the more we'll see how much prosecutorial misconduct has occurred over 100 years since we began to look at this, and how much went on before then. But we'll have Ben back. We'll talk more about that. It's a topic that will never leave us in this show, because injustice for all is predicated upon the injustice of the system. We're going to hear more from people who have experienced this, who went to prison. We're going to hear from attorneys who represented people in that position. And I must say to you that it's important that if you believe that there is injustice, I don't want to say necessarily for all, but it seems that way to me, you should become a subscriber to this podcast. If you are enjoying our programming, like, comment, and subscribe to our channel, and hit the notification bell for future episodes. We appreciate your participation. It will tell us that you like what we're doing, and we're going to continue to target this area of the law. We'll be here a long time if you help us out. So, see you next week. Thank you.